Hi, my name is Ilanah Fhima. I'm the course convener of International and Comparative Law of Trademarks, Designs and Unfair Competition, ICTM for short. This is a full module, so 22-week course taught by UCL in conjunction with Queen Mary and King's College London. It's teachers on this course are myself, and I'm the UCL course convener, and also Professor Spiros Maniotis from Queen Mary, Professor David Llewellyn from King's College, and also Professor Sir Robin Jacob from UCL, who's a former Court of Appeal judge. And we're all trademark freaks. This is a course where we get to, I think, exercise our passionate side about trademark law. In some ways this is actually quite a mixed and varied course. The key focus of it is on trademarks, but it's a course where we look quite deeply into trademark law. Our other course, the Law of Trademarks and Brands, is a course where we try to give a comprehensive overview of European and UK trademark law. We're trying to do something a bit different in this course. What we do in this course is we look at the law of trademarks, and we do cover the UK and European side of things, but we also look at other jurisdictions. So we look at the US in particular, and on the unregistered trademark side where things aren't so harmonised, we look at other European jurisdictions. But we also look at other issues of trademark law. So we look at the social and cultural side of trademarks, we look at the economics of trademarks, and we look a bit at the history of trademarks. This is a course which is examined wholly by examination. We've got a 3 hour and 15 minutes written examination in the summer, and it's a closed book examination, except that you can bring in the statute book that you'll use for the course, and we also provide you with supplementary materials for some of the foreign law, which won't necessarily be in your statute book. This is a course which is very interactive. It's something where we really want to know what you feel, what you think about what we're saying. Even though it tends to be quite a large course, it's just commonplace that we stand there and we have a good discussion going about the rights and the wrongs of trademark law. We don't actually have a course textbook for this course. This is one of the downsides of the fact that this is a unique course. This is a course where I don't think there's necessarily a direct equivalent of this course being taught in the UK. There are some trademark courses which focus perhaps a bit more narrowly, but I don't think there's another course quite like this one. The downside is there's no one course textbook for this. There's no course textbook that covers the UK and the US and France and Germany, etc. What we do is we give you very comprehensive materials. So our course handouts tend to be very detailed, and we also send you off in the direction of further reading, and we try to get you to engage not just with the UK materials but also with the materials, for example, from the US, which are readily available to you. So we direct you to the materials that you can get through Westlaw, so the core US trademark law text, and we direct you to look at US journal articles as well as UK and European journal articles, and we support you in how to find these materials. But what you are doing is you're engaging with the materials that, say, trademark law students and even trademark practitioners and academics, both here and in the US and also across Europe, will be reading and looking at. In terms of what we cover in the course, we start off with a general introduction to trademarks and the issues involved, the economics of trademarks, the history of trademarks, all that background information. We then go on to look at unfair competition. A lot of the first term is spent looking at unfair competition. Unfair competition is the sort of protection that you have when you don't have a registered trademark, and it looks quite different in different countries, even different countries across Europe. So what we try to do is we try to look at the policy issues behind the unfair competition law and ask, why do these jurisdictions have such different laws? One of the live issues is how much trademark owners, or even just traders, should be able to get protection in the absence of confusion. So when consumers know exactly what they're getting but there's something else going on. So to take an example, if somebody comes along and they sell a perfume and it says on it, smells just like Chanel No. 5, then consumers know that they're not getting Chanel No. 5. They know they're not confused. They know they're not buying a product which is made by Chanel, but at the same time there's something else going on. The defendant could be said to be doing a rip-off of Chanel, taking an advantage that they haven't earned. So one of the big issues that we look at across unfair competition is, should it be enough to just take advantage of somebody else's effort, or should you need more than that? And we look at that from the perspective of the United States, we look at it from the perspective of the UK, and we also look at unfair competition in France and Germany, and we highlight the fact that even though we've got a harmonised European Union where there's meant to be a single market, there are actually very different approaches in this respect. And this is actually something that goes on to shape our trademark law, our registered trademark law, which actually is harmonised, but you have all of these tensions bubbling under the surface of how far should protection go and how far has protection historically gone. After unfair competition, we go on to look at registered trademarks. We look in some detail at trademark registration in the United States. So what kinds of marks will be registered, how much protection will those marks get, again looking at how far should there be protection without confusion, and also looking at defences, so making that balance. When should there be a public interest in allowing other people to make use of somebody else's trademark, for example, to describe their goods or to use their own name, something like that. We then look at the same issues from the European perspective, and we highlight situations where there are differences and also hit situations where there are similarities, and we question what this means about the nature of trademark law, the functions of a trademark, and what this means just about different circumstances in the different countries. After that, we go on to look at special topics. These are particular issues in trademark law that we think are particularly interesting. They vary a little bit from year to year, depending on sort of what's a hot topic at the time, and also a bit on the interest of the people who are teaching the course and what their current research is. But certainly things that we've looked at in the past and are likely to look at again. Issues of comparative advertising, so how much can you make a comparison between your goods and somebody else's goods and use the trademark to make that comparison. So to say, for example, my toothpaste is cheaper than Colgate's toothpaste but is just as good. We also look at parody, so how much should you be able to use somebody else's trademark to make either a sort of in a creative way or even in a political way, so to make a political point with more force. Other things we look at or have looked at are trademarks in the internet. Should you be able to use somebody else's trademark on the internet? Are there slightly different rules because there is different technology? Is the internet a bit of a free-for-all? We also look at parallel importation. How much should you be able to sell somebody else's genuine goods in another country? So let's say you get genuine Levi's jeans from the US, this is a real case, and you bring them into the UK. Should you be able to sell them in the UK? Or should Levi's be able to say, hang on, you're using something where I've got the trademark in the UK. I don't care that I made those goods. I control that trademark in the UK. We also look at designs and how much protections designs give compared to trademark law and the overlap, and functionality, so how much should it be possible to protect a functional trademark, so something which maybe people recognise but also which does a job, so other traders may want to use it. The classic example being the Philips three-headed shaver. Philips had in the UK a trademark registration for its three-headed Philly shave, and everybody in the UK knew what that was. Everybody knew 3 heads equals Phillips, but at the same time, they chose these 3 heads because that was the most efficient and best way of shaving. So should they be able to have the monopoly on this? That about wraps up what we cover in the course. In terms of overlap with our Law of Trademarks and Brands course, there is some overlap. We're certainly covering the same material. It's both about trademarks. That's a good course to do if you want to look perhaps at more depth, particularly at the European situation. If you perhaps want more of an overview, and you also want to do, you want to understand the sort of social, historical, cultural side of trademarks, and you want to see the comparative side of trademarks, I'd say that the International and Comparative course is a good course for you. What you can do is you can do both. There's no restriction on doing both courses, and they complement each other very nicely. They are a bit different in focus, and lots of people have done both courses and enjoyed them. This is really a unique course. It's a very good course to do if you want to look deeper into trademarks, and I don't think there are many, possibly not any, courses in the UK which are looking at trademarks in such detail. We cover the comparative side of things, so it's actually something that works very nicely for people who want overview of trademark law in lots of different key important jurisdictions. It's something which I think has quite helped some, for example, European students who've gone back to their home countries to practice. So it's helpful in that respect. It's also very good because it familiarises you with the really important jurisdictions. In particular, I think it's one of the most detailed coverages of US trademark law in the UK. I don't think there are many other institutions in the UK which are actually looking at US trademark law in any detail. This is a course which is really taught by people who love trademarks. We're all passionate about them. We're researching in it. We are, or a lot of us are or have practiced in it. Rob and Jacob has actually been involved in some of the big decisions which we actually talk about during this course. It's also a course where we very much want to hear your thoughts. It's a very interactive course. It's a course where we really want you thinking, and we actually want you doing some research. We really encourage you to get out there and to engage with the key materials and to engage with the sorts of materials that students in the US would be looking at. So really sort of to give you the best of both worlds. It's a UK-based course, but very much with an eye across the world. It's also a course which complements other areas of intellectual property very nicely, so it goes very well with them, and it also fits very nicely into a commercial profile, or even somebody who has a particular interest in freedom of speech and media issues and things like that. It works very well there. And last of all, it's actually really good fun. It's a course that we all enjoy. Certainly the teachers enjoy it. Hopefully the students enjoy it too. They certainly always engage with it. Thank you very much for watching. I hope to see you all in September.